We're good now.
Good morning. My name is Dr. Tamir Baran. I'm a professor in the Department of International Relations and Humanities at the Tecnológico de Monterrey, campus Querétaro, in Mexico. Today, I want to talk about international law. And in particular, I'm going to focus on three institutions, all based in The Hague, the Netherlands or Holland, which embody the principles of international law. And those institutions are the following: the International Court of Justice, or the ICJ, the International Criminal Tribunal for the former Yugoslavia, and number three, the International Criminal Court. Okay, I want to begin by tracing the origins of international law and its evolution. I then want to attempt to tease out the differences between these three set institutions, that is the ICJ, ICTY, and the ICC. And then the argument that I want to make is that international law has rapidly evolved in the 20th and 21st centuries, and that the International Criminal Court, which came into force with the Treaty of Rome in 1998 and officially came into force in 2002, represents the permanent institutionalization of international law and a very important evolution in the way we think of human rights, in a manner that no longer allows states to hide behind the principle of national sovereignty while at the same time egregiously violating the human rights of its citizens. Okay, let me begin by discussing what international law is. International law is essentially a set of customs and rules thought to be binding in relations between states and nations. It's important to point out that the signatories of international law are states rather than individuals. And it's also important to point out that international law is not binding and is based merely on the consent of the state parties. In our discussion today, I'll be merely concerned with a part of international law, or a facet of international law, that is the laws of war and international human rights law. I should also point out, in respect of international law and the idea that it's not binding, the famous English political theorist Thomas Hobbes pointed out that covenants without swords are but empty words. Meaning that international law is essentially not binding because there is no coercive force in the international arena that can actually get states to follow and obey international law. Okay, let's now move on to what are the origins of international law. In the cases of laws of war, there are religious and secular traditions which seek to protect civilians and soldiers alike in times of war, and also restore peace to the international order. Let me give you two examples. One is, in fact, ancient and religious, and another is more secular and relatively modern. In Deuteronomy, in the Old Testament, that is in the Jewish tradition, it states very clearly that in times of war, those that are engaging in wars must limit the amount of collateral and environmental damage. That is, that they must be careful not to harm civilians as well as the environment in advancing their military objectives. Second example is much more modern, and it comes from the 19th century. And that is the Lieber Code of the 19th century, promulgated in 1863 by the Union Army in the American Civil War, and it is considered to be a critical code in the protection of civilians in times of war. It is said to have influenced the creation of the Geneva and Hague Conventions later on in the 19th and 20th centuries. I just mentioned the Geneva and Hague Conventions. These are, in fact, other famous examples of international law, and in particular, attempts to defend and protect soldiers and civilians alike in times of war. The Geneva and Hague Conventions. The Geneva Convention, in fact, comes first, and it dates to 1864 as well as 1949. The Hague Conventions, two major sets of laws were passed in 1899 and 1907. With the Geneva Convention, the first one that I mentioned in 1864, there was an attempt to protect the wounded and sick in armed conflicts. The Hague Conventions talked about the pacific settlement of international disputes between states. It attempted to eliminate certain types of weapons that were thought to be beyond the pale of humanity. These conventions, that is the Geneva and Hague Conventions, also talk about things like the opening of hostilities, and in particular, they're very concerned with protecting civilians and soldiers and prisoners of war from harm in times of war. The idea here is that military necessity, attacking combatants, is what war should do, and not civilians or soldiers that have given themselves up to the enemy. Okay, let's move on now beyond the Geneva and the Hague Conventions and the Lieber Code, and let's move on to World War II, because I think it was fundamental, and in particular, the Holocaust, the elimination of 5.9 million Jews, and a number of other so-called undesirables eliminated by the Nazis, in particular 3 million Poles and more than 500,000 Gypsies. I think that the genocide of the Holocaust represents a very important period in history, and it's going to give impetus, in my estimation, for the evolution of international law. Let me give you some examples here. In 1946, after the end of the war, we know that there were the Nuremberg trials in the city of Nuremberg in Germany, where prominent members of the Nazi leadership were sentenced for their crimes committed against humanity. This was seen as victor's justice because the trials were led by the Allied powers. But nonetheless, there was here the principle that leaders will have to pay for violations of egregious violations of human rights. And another important point about the Nuremberg trial is that it was an ad hoc court, meaning it was a court that was created specifically to look at Nazi crimes during the war. And then it was disbanded after. And in this respect, it's very similar to the International Criminal Tribunal for the former Yugoslavia, which will be disbanded, we think, in 2014 or 2015, once all the cases are heard for the crimes that occurred during the course of the civil war in the former Yugoslavia from 1992 to 1995. Now, the other example of an ad hoc court was the Tokyo trials for the Japanese rulers and military generals that were also responsible for egregious violations of human rights in the course of World War II, and those were held in 1954. The other thing that I should mention in this period, just after the war, is the passage in 1948, I think is very, very significant, of the UN Genocide Convention. And in fact, before that, we did not have a definition of genocide. That definition is then going to go into the definition of genocide that is in the International Criminal Court, which was created with the Treaty of Rome in 1998. What happens after the war also is the Cold War. This mighty ideological struggle between the socialist Soviet Union and the liberal United States of America. And in a sense, what this Cold War does is it puts a stop on discussions of creating a permanent international criminal court that could end the impunity of political and military leaders for genocide, war crimes, and crimes against humanity. Well, the Cold War does end. We know the Berlin Wall falls in 1989. We know that the Soviet Union disintegrates officially in 1991. And then this gives impetus again for the creation of a permanent international criminal court known as the ICC. Remember that this permanent international court is going to be different from courts of the past because it is no longer an ad hoc court looking at particular crimes and then disbanded after the fact. In 1998, something momentous occurs in the city of Rome, in Italy. The Treaty of Rome is signed, promulgating the International Criminal Court. And the International Criminal Court has under its ambit 3 major crimes, and these are considered the worst crimes that individuals can commit anywhere in the world, because in many instances they are crimes that target people because they are what they are. Culturally, religiously, ethnically, or nationally. And these crimes are genocide, considered by Raphael Lemkin to be the crime of crimes, the worst possible crime, crimes against humanity, and war crimes. The other crime that will be under the ambit of the International Criminal Court, which is known as the crime of aggression, which essentially means the invasion of another state, contrary to the principle of national sovereignty, which is protected by international law and by the United Nations. That crime of aggression, in fact, will be part of the International Criminal Court as well, sometime we believe maybe in 2017.